Welcome to this informational video on fraternization in the military. Military fraternization is when military service members of different ranks and positions engage in inappropriate personal relationships. Fraternization doesn't just include romantic relationships, but overly casual friendships between subordinates and senior members. Relationships between subordinates and those that outrank them within an organization can undermine the chain of command, and disrupt good order and discipline in a military unit. What is fraternization in the military? The Department of Defense issued a uniform policy for all branches to follow in 1999. According to the policy, certain relationships that are always improper are, as an example, romantic relationships, and personal relationships between officers and enlisted service members involving gambling or business ventures. Regardless of specific circumstances, any type of relationship that has an adverse effect on the unit or chain of command, or can include the appearance of impropriety, is prohibited. The military encourages a certain level of relationship building among members of all ranks with activities that fall under the purpose of team building. Activities like softball fall into this category. Contact between different ranks and positions in this context is allowed. There are a few exceptions to fraternization, such as if a couple is married prior to attaining their ranks and positions of differing status. Also, occasionally, military reservists may have an ongoing business relationship in their civilian jobs. Regardless of these exceptions, the relationship must not have an adverse effect on the unit. Fraternization can be charged as an offense. Fraternization is a criminal offense under UCMJ Article 134, relating to the prejudice of good order and discipline in the armed forces, or Article 92, failure to obey a direct order. This is determined if the conduct has compromised a chain of command, has resulted in the appearance of partiality, or otherwise undermined good order, discipline, authority, or morale. Most offenses do not lead to a court-martial unless the offense meets these factors outlined in the Manual for Courts-Martial. A person charged with fraternization may have a reasonable defense. Here are some examples of potential defenses to fraternization: false accusation, failure to prove that the chain of command or morale was compromised, proof of legal marriage to enlisted member, or proof that alleged fraternization was under the auspices of official duty. An experienced military defense attorney can make all the difference for service members who face charges of fraternization. For more information and to see successful case results, please visit the law office of Peter Caggiulari Jr. at ucmjlaw.com.